Well, it's like we never left. We're back again to talk about Bryan Kohberger, who has officially been indicted. Arraignment seems like it's going to be on Monday. We will hear his plea. Will it be guilty? Will it be not guilty? I assume it's going to be not guilty. Will he waive his speedy trial rights? I think he shouldn't. I think he should demand speedy trial because he can always waive it later. Keeps the pressure on the prosecution, forces them to give all the discovery as quickly as possible. They've already provided some. Defense thinks they're not providing certain things or even trying to hide certain things. They filed a motion to compel exculpatory evidence, which the prosecution puts in quotation marks. We've broken all that down, but the process is going to change a little bit now that he's been formally charged and we believe the arraignment to be on Monday. So we're going to get into that. A lot of this is going to be Q&A because you guys had questions about what this means. So get your questions in now. John will star them up and we will answer them in a few minutes. Some new documents have been filed. I did want to look at them as well. They just left my screen, so I don't know specifically where they are. So we can talk about them. They're pretty simple. But now that he's been indicted, we will talk about what is going to happen. Hit that like button. Subscribe to the page, please. We bring you the content you guys ask about. Follow us on Instagram and Twitter because all you were asking for another video on this at Tragos Law. And that's why we're doing it. So he's indicted by the grand jury, no preliminary hearing. To some people's surprise, grand jury proceedings in Idaho are actually less common than preliminary hearings. The more common approach is to go forward with a preliminary hearing in front of a judge and get probable cause that way. It also probably didn't come as a surprise to the defense. I think they probably knew about it, and I think they were probably okay with it. They probably knew they were going to lose whether it's a grand jury proceeding or preliminary hearing. They also knew that when they waived his right to a speedy preliminary hearing, that at any moment from the arrest of Bryan Kohberger to the preliminary hearing, the state could go and do this grand jury in secret. And while it isn't secret and there's no lawyer, no defense lawyer there, the state does have to present a balanced case and they have to present exculpatory evidence if it exists for the defendant. Now, do they present it as zealously as a criminal defense attorney would on behalf of their client? No. Is anybody poking holes in their arguments? No. Is anybody cross-examining witnesses? No. But they do have to present at least some type of exculpatory evidence if it exists. Now, most of the time, there are situations where the state is going to choose a grand jury over preliminary hearing, but they're going to win either way. And that's what I think this was. I also think that it's not as secret of a process in Idaho as you may think, because the defense can ask for and receive a transcript of the grand jury proceeding, of what the prosecution said, what they read, if any witnesses testified, what they said, what evidence was presented. Now, in a grand jury proceeding, just to kind of explain what it's kind of like a normal jury trial where the prosecutor will pick an actual jury, seat a jury, explain to them what they have to do. They start the case, they read the evidence, they may make some arguments, and then the jury has to actually make a decision. And the decision they have to make is not whether he's guilty beyond a reasonable doubt, but instead, was a crime probably committed, and did Bryan Kohberger probably commit it? Probable cause, a much lower bar than beyond a reasonable doubt. But why state attorneys sometimes will choose a preliminary hearing over a grand jury is it's cheaper, cleaner, easier. You don't have to pick a jury. You don't have to teach a jury. You don't have to explain to a jury what they have to do. You don't have to wait for a jury to come to a decision. So that's why sometimes they'll just go preliminary hearing. Also, what's interesting is if a witness testifies to in the grand jury proceeding, that can be public information. However, in this case, the new documents that were filed, that I don't think you care to see, because it simply is the state's motion to seal the list of witnesses that testified at the grand jury and the court ordering their sealing. Now, what is interesting about that, and I guess I could pull it up here, because there is one interesting thing about this to me. Let's pull them up. Why not? We just read 30 pages. What's two more going to hurt? All right, so here's the motion to seal. Comes now, state of Idaho. Prosecuting attorney move this court to seal the names of all the witnesses examined before the grand jury. In support, the state respectfully represents to this court that it had received numerous complaints from potential or prospective witnesses or their families and associates regarding being harassed, both in person and via social media. The reports of harassment have included threats, as well as what appears to be intimidation. Given this and the broad publicity surrounding these proceedings, the state respectfully submits that releasing the names of these witnesses who appeared before the grand jury would invite additional harassment, intimidation, and possible threats, and undermine not only the integrity of this case, but the parties' prospective rights to a fair trial with an impartial jury. The state respectfully requests this court seal that witness list. This right here, ladies and gents, is a little bit of a precursor or a preview as to what we are going to see in this case. They are going to fight tooth and nail with arguments like this to block access. And it may be warranted because I don't want any witnesses to be intimidated or harassed or threatened. But this could be the argument made by the state. This could also be what the defense's expert is going to come in and testify about. And then we could see if the court just bans everything. No cameras, no audio equipment, no nothing. Or maybe next day stuff like Lori Vallow. Because immediately, let's go ahead and jump to the order, the old same day order. The judge grants this order. And what's also interesting about this order is we see down here, John C. Judge, is a district court judge who is now taking over the case. And that's another thing that changes. The magistrate is no longer in charge. This is in the jurisdiction of the district court. He will be making the decisions now in this case, which means he will be looking. Yeah, right now it says, Penny for your thoughts. Right now it says video and audio delayed. I'm waiting to see if that holds true. We had that in the Vallow case, and then it got taken away. So I'm still waiting. I know what it says right now. I know the chat. I appreciate you guys letting me know. I know what it says. But if they're filing this motion, do you really believe that they would have had this preliminary hearing and not tried to seal it or keep things secret by making the same arguments? And that's tough for a judge not to agree to. So that's just my opinion where I'm kind of looking at this. I hope I'm wrong, just to be clear. But district court judge comes into play. What that could affect coming forward is the gag order. The magistrate's the one who wrote the gag order. The magistrate's the one who they originally or now are asking to amend or get rid of it. Now that's going to be a decision for this judge. He could throw it out. He could amend it. He could make it more strict. He could make it less strict, or he could write a completely new non-dissemination order that he finds to be appropriate. So usually judges want to agree with each other. They don't want to upset the milk carton. Is that what it is? I don't even know why I try with those things. But yeah, usually judges don't want to overrule things other judges do, and they have respect for each other. So I don't think he's going to just totally disregard what the prior judge did, but somebody just said the judge is a woman. I was like, wait. I knew it was Judge. No, I don't. I think John C. Judge. I'm confident that's a man. Confident. But, all right. Let's get to your questions now. Some new members, Mama French and Lisa C. Star Sorcerer. What type of people are on a secret jury? Been a member this week for 1 year. Thank you for all you do. That's awesome, Star Sorcerer. So the grand jury is picked in a very similar way that normal jurors are picked. You can show up for jury duty and you might not even know that you're going to get picked for a grand jury. In most jurisdictions, I should say. L, when will the indictment be released to the public, or will it be released? I believe it will be released. I just don't know when. Kat, will the public only see the evidence once it goes to trial? Possibly. We've seen that happen in other cases. These are some answers I just don't know yet. Google says 99.5% of defendants that get indicted get convicted. I don't think that's correct. I don't think that's correct. John, if indicted, do you still get a defense to protect yourself? I thought a grand jury is no defense. So if you get indicted, you have the defense that's defending you throughout the case. A grand jury does not decide guilt or innocence. They just decide probable cause if this case is going to continue forward. They decided yes, and they indicted him. This is still going to be a normal trial, and his defense team is still going to be able to defend him. It's also a way to keep all the information out of the public eye, correct? Mo, did they check to see if the jury knows about the case in a grand jury? So yes, but as you can imagine, it's not as strict or as crazy, but they do try to pick a fair and impartial juror for a grand jury as well. Yes. Whiskey, thank you so much for walking us through all of these cases. Do you think we will see the arraignment and pretrial hearings? I think because we already kind of saw something similar to the arraignment when the magistrate read his charges, I think it's possible we will see the arraignment pooled and showed on a delay. But I'd be surprised if they show us anything. I would have been surprised if they ended up showing the preliminary hearing or if they showed a trial at this point. Tracy, welcome to the membership crew. Will all of this be discussed on Monday when he makes his plea? So we will be discussing it here. I don't know what they're going to be discussing there just yet, but I expect him to plead not guilty. And then they have 60 days from his plea to decide whether or not they are going to file their notice of intent to seek the death penalty. So we will see if they intend to seek the death penalty soon as well. Welcome, Daphne. John, why or when would someone not want to defend themselves without an attorney for defense? Better question. When has this worked ever? So Deshaun Watson, actually, if you remember way back when we covered that, the grand jury found not to indict him, which was interesting in multiple jurisdictions. So it does happen. This was not the defendant's choice. This was the prosecutor's choice. They chose preliminary hearing, and now they've changed their mind and gone before a grand jury, which is their prerogative. And again, this is not the final trial. This is just to find probable cause. Does the state went to the grand jury in order to protect the surviving roomies from meeting the defense team before trial? It's possible. There's lots of reasons they could have gone this route. Kat, where does he go from here? Will he stay in the same jail or be transferred to a prison or somewhere else? I think he's going to stay in the same jail as they prepare for trial with his defense team. Regan, if he is tried in front of a grand jury, he is not tried in front of a grand jury. He's just tried in front of a jury of his peers, which is the same thing, but a grand jury is just a different process to indict, not to convict. Is it the same as Casey Anthony and he cannot be tried again? So this grand jury is totally separate from the actual jury trial. This is just to find probable cause, which they've done. He will have a normal jury trial if he wants one. He will get his day in court like Casey Anthony. And if he wins, no double jeopardy. He cannot be tried again. Carissa, why didn't they convene a grand jury in the beginning? I don't know. Prosecutorial decision. Laura M. Question. If your defense, how vigorously are you fighting to keep the trial from being live streamed? Because I'd fight like hell. I probably would too. Because I think the court of public opinion is condemning him. I think it's only going to be bad for your case. So I would do everything I could. And especially if the prosecution's with me, we don't want witnesses intimidated on both sides. We don't want poisoning of the jury pool for people convicting him before they ever even show up. So I would fight. We definitely need don't upset the milk carton merch. You're the best. When you say it, when you write it like that and I read it out loud, it just seems even dumber. Robin Noel. Question. Now that things have changed, what will Monday mean? Enters a plea, then set a trial date, or is there other steps I'm missing? Thanks, Peter. I love this place. So discovery is still going to happen. They're not going to set a trial date yet. They'll kick it out for another hearing. They may set a trial date at that hearing if he demands speedy trial within 6 months of him entering this plea and being arraigned. Within 60 days, we'll know about the death penalty, but depositions, documents, questions, discovery is going to happen, and we're going to be pushing towards a trial. Northern Ireland. It seems the grand jury process gives a huge advantage to the prosecution, so why would they ever not choose it? The preliminary hearing gives a huge advantage to the prosecution as well. They're way further ahead of the game. They have all the information the defense doesn't. The judge almost always agrees with them. So either way, they have a very high likelihood of success. But you're right, it is a bit one-sided, even though they do have to present the defense's exculpatory evidence if it exists. And the point is, they usually win either way, because it's their choice to bring this stuff. Nobody forces them to go forward on this case. If they don't feel like they have enough, they shouldn't go forward on it in the first place. So you have law enforcement, prosecutor's office coming to the same agreement before they ever even go to a grand jury or preliminary hearing. So I will say it is kind of difficult to do hours and hours of just boom, 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 these videos. My voice starts to feel it. My brain starts to feel it. No notes, reading documents, reacting, answering questions. But it's fun. I like it. I enjoy it. I love the banter with you guys. You make it so enjoyable. You guys aren't miserable. You're not overly critical. I'm sure I misspeak all the time, mispronounce words, miss things as I'm reading, mess up questions you guys ask. So I appreciate the grace that you give me throughout these videos as well, because I know a lot is needed. So I want to say thank you for that. I know it's not perfect. And I appreciate you guys so much. I do appreciate that. All right. So I wanted to say that on the way out, but I'm done. I need a little break here. I got to get back to real work. I have about a couple hours left of that today. Yes, murder and burglary, Dana. Those are the same charges he was originally brought with and arrested for. Burglary is just entering a dwelling unlawfully with intent to commit a felony, which was the murder in this case. All right, hit that like button, everybody, and subscribe if you haven't. I'm out of here. Until tomorrow. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.